9:05 p.m., a suburb of St. Paul, Minnesota. A routine traffic stop, faulty brake light. Philando Castile hands over his insurance card. The officer tucks it away. Everything is calm. Everything is normal. Then Castile does exactly what his firearms instructor taught him to do. Exactly what the class said. Exactly what responsible carriers are supposed to do. He says, "Sir, I have to tell you that I do have a firearm on me." 10 seconds later, 7 shots are fired into the car. Castile had a valid permit. He followed his training. He used the right words, and he never made it home that night. Now here is the question nobody is asking. If doing everything right still wasn't enough, what actually protects you? Because in the next 20 minutes, I'm going to show you something that no CCW class teaches, no mainstream channel covers, and no courtroom decision fully explains. If you are a legally armed American, this is the most important conversation you will have this year. Subscribe right now, because we are just getting started. Let me be direct with you about something before we go any further. 21.5 million Americans currently hold a valid concealed carry permit. That is 8.2% of every adult in this country. This is not a fringe issue. This is not a niche conversation. This is tens of millions of people who wake up every morning, make a legal choice, and carry a firearm. And most of them have no idea how exposed they actually are the moment a police cruiser pulls up behind them. And here is where it gets serious. 29 states now allow permitless carry, meaning you can legally carry a firearm without a permit at all. Constitutional carry, no license required, which sounds like freedom, and in many ways it is. But it also means a growing portion of legally armed Americans have never sat through a single class that explains what to say, what not to say, and what the law in their specific state actually requires of them during a traffic stop. Now layer on top of that what is happening at the highest levels of the American legal system right now in 2026. Bruen, in 2022, reshaped the entire constitutional foundation of gun rights in public spaces. Rahimi, in 2024, carved out exceptions. And Wohlford versus Lopez, a case the Supreme Court accepted in October of 2025, is still working its way toward a decision that legal analysts believe could redraw carry laws across multiple states overnight. Your rights are being rewritten right now, in real time. But here is what none of those decisions protect you from: the first 30 seconds of a traffic stop. That gap between what the Constitution says and what happens on the side of the road at 9 o'clock at night, that is where everything can go wrong. And that is exactly what we are here to close. Here is where I need you to pay close attention, because this is the part that most people get wrong, and getting it wrong is exactly what makes you vulnerable. You have seen the headlines. Supreme Court 6-3 decision changes everything for gun owners. You have seen it shared across social media, across forums, across group chats. And the framing is always the same: this decision either protects you completely or destroys your rights entirely, depending on which side of the aisle the person sharing it sits on. The truth is more complicated and more dangerous. Let me walk you through what actually happened. In 2022, the Supreme Court handed down New York State Rifle and Pistol Association versus Bruen, 6-3. The ruling established that the Second Amendment protects an individual's right to carry a firearm outside the home for self-defense, and that any government restriction on that right must be grounded in historical tradition dating back to the founding era. This was a seismic shift. Courts across the country are still processing its implications today. Then came Rahimi in 2024, also 6-3. The court ruled that individuals subject to domestic violence restraining orders can be temporarily disarmed. This was the first major limitation placed on Bruen's framework, and it signaled that the 6-3 majority, while broadly pro-Second Amendment, is not unlimited in its protections. Now Wohlford versus Lopez is waiting in the wings. Arguments were heard in January of 2026. A decision is expected, and depending on how the court rules, carry laws in states like Hawaii and potentially others could change dramatically in either direction. Here is what I want you to understand about all of this. These decisions expand your constitutional rights on paper, and that matters. But not a single one of them reaches into a traffic stop and tells a police officer how to interpret your words, your movements, or your intentions in real time. And here is the legal detail that should genuinely stop you cold, one that almost nobody in this space is talking about. In Berghuis versus Tompkins, the Supreme Court ruled that simply staying silent is not enough to protect your Fifth Amendment rights. You must actively and unambiguously declare that you are invoking your right to remain silent. If you say nothing, courts have held that you may be considered to have waived that right entirely. Read that again slowly. You have to speak to protect your right not to speak. That is the gap between constitutional rights and street-level reality. That is what no headline captures. And that is what the next section is going to break down, one word at a time. I want you to stay with me here, because what I am about to walk you through is not theory. This is documented. This is time-stamped. This is real. July 6th, 2016, Falcon Heights, Minnesota, 9:05 in the evening. Philando Castile is driving home from a grocery store. His girlfriend, Diamond Reynolds, is in the passenger seat. Her 4-year-old daughter is in the back. 9:05 and 15 seconds. Officer Geronimo Yanez approaches the driver's side window. Routine greeting, brake light issue. Everything is measured. Everything is calm. 9:05 and 38 seconds. Yanez asks for license and proof of insurance. Castile hands over the insurance card without hesitation. 9:05 and 52 seconds. This is the moment. Castile says, and these are his exact words, "Sir, I have to tell you that I do have a firearm on me." Yanez responds, "Okay, don't reach for it then." Castile says, "I'm not reaching for it." 9:06 and 2 seconds, 7 shots. 10 seconds after Castile first spoke. Now here is what the investigation revealed afterward, and this is the detail that should make every legally armed American stop breathing for a moment. Dan Wellman, the owner of the firearms training facility where Castile had taken his carry course, confirmed that every single class explicitly teaches students that saying, "I have a gun," is not the correct way to notify an officer. They knew. They taught it. Castile almost certainly heard it. He still did not make it home. I am not telling you this story to suggest there is no hope. I am telling you this story because it proves something that is uncomfortable, but absolutely necessary to understand. Correct words are the floor, not the ceiling. What happens in those 10 seconds, the sequencing, the timing, the position of your hands, the tone of your voice, the way information lands in a stressed human brain, that is what determines the outcome. Not the policy, not the permit, not the precedent. That is what we are going to fix right now. If you are still watching right now, I want you to understand something. Most people clicked away in the first 3 minutes. You did not, which tells me you are serious about this, and that means what I am about to share is going to matter to you in a way it would not matter to anyone else. Because here is what I have not seen a single concealed carry class teach. Not one mainstream channel cover, not one legal breakdown address. Every piece of advice you have ever received about traffic stops focuses on words. What to say, what not to say. Nobody talks about what is happening inside the officer's brain before your words even register. That changes right now. Let us get into it. Let us get 5 phrases, 5 moments where legally armed Americans unknowingly hand over their safety. And for each one, I am going to give you the exact words to use instead, plus something nobody else is giving you. The reason your brain and the officer's brain are working against each other in that exact moment. Here is the legal problem. In states without a proactive duty to inform, you just volunteered information you were not required to give. In states where you are required to inform, you gave that information with 0 framing, 0 control, and 0 context. But here is what nobody tells you about the neuroscience. The word gun is a threat trigger. It is processed in the amygdala, the brain's threat detection center before the prefrontal cortex, which handles context and reasoning, has any chance to evaluate the situation. You are not talking to a calm, analytical mind in that moment. You are talking to a nervous system that just received a threat signal. The words that follow gun almost do not matter because the brain is already preparing a response. What you say instead, "Officer, I want you to know I am a licensed carrier and I am fully cooperating with you today. How would you like me to proceed?" You lead with cooperation. You lead with calm. You give the officer's brain something to work with before the firearm even enters the conversation. The legal problem is straightforward. You have just handed the officer a legally significant piece of information that in some jurisdictions opens the door to a lawful request to secure that firearm for the duration of the stop. The cognitive problem is subtler. You just created an attention anchor. Every movement you or anyone else in that vehicle makes toward that location, even accidentally, even innocently, is now being tracked and interpreted through a threat lens. What you say instead: I am a lawful carrier. I am happy to follow your instructions exactly. Then you stop. You wait. You let the officer lead every single step from that point forward. The legal reality is that your permit does not end the stop. It does not limit the officer's authority to investigate, to ask questions, or to detain you for a reasonable period. The permit tells them you cleared a background process, nothing more. But the psychological damage is in those 4 words at the end. So it is fine is almost always delivered with a tone that reads as dismissive, not because you mean it that way, but because the sentence structure itself implies the matter is closed. You are signaling to the officer that their continued presence is unnecessary. That is not a signal you want to send on the side of a road at night. What you say instead: here is my carry permit. I will follow your instructions completely. Present the document. Offer cooperation. Say nothing further. This comes from a genuinely good place. You want to seem normal, relatable, non-threatening. But every single piece of voluntary information you offer is a piece that gets noted, recorded, and potentially reframed in a context you never intended. I carry everywhere I go, said casually and friendly in a traffic stop, can later be characterized as a statement of habit relevant to an entirely different legal question in an entirely different proceeding. What you say instead: I would prefer to answer only what you need for this stop. I am cooperating fully. You are not being difficult. You are exercising a right that courts have broadly recognized: calm, polite, and concise. Said correctly, at the right moment, in the right tone, this is a legitimate legal question grounded in real constitutional principle. Said aggressively, repeatedly, or early in the stop, it does something that no amount of correct wording can undo. It establishes an adversarial frame. And once that frame exists, every action you take, every movement you make, every word you say afterward gets interpreted through it. An officer conducting a lawful traffic stop has the authority to detain you for the reasonable duration of that stop. Demanding to know your status combatively does not legally end the stop. It simply poisons everything that comes after it. What you say instead: Officer, I want to cooperate fully. Once we are finished here, am I free to go? Same legal question, completely different energy. The tone turns a confrontation into a conversation. Here is the principle that connects all 5. De-escalation is not weakness. It is not surrender. It is strategy. The roadside is never the place to win a legal argument. That is what courtrooms and attorneys are for. Your only job in those 2 to 5 minutes is to get home safely with every legal option still open to you. Now I need you to understand something that the vast majority of concealed carry content gets completely wrong. Laws vary by state is not information. It is a disclaimer. It is what people say when they do not want to do the actual work of breaking it down for you. So let me do that work right now. There are 3 categories of states, and which category you are in determines everything: your script, your obligations, your legal exposure, and your risk level the moment an officer approaches your window. These are states where you are legally required to proactively notify a law enforcement officer that you are carrying without being asked at the first point of contact. Alaska, Arkansas, Louisiana, Michigan, Nebraska, North Carolina, Texas, and Washington, D.C. fall into this group. In these states, silence is not neutral. Silence can be a criminal violation. If you are in a must-inform state and you say nothing, you are not being cautious. You are breaking the law. The Florida, Illinois, Ohio, Pennsylvania, and roughly 15 additional states require disclosure only when an officer directly asks whether you are carrying. Until that question is asked, you have no legal obligation to volunteer the information. But the moment it is asked, you must answer truthfully and immediately. 29 states currently allow constitutional carry. In many of these states, you have no legal obligation to disclose that you are armed under any circumstances. But here is the critical misunderstanding people carry into this category. No duty to inform does not mean no risk. An officer who discovers a firearm they were not aware of is an officer who was just surprised. Surprised officers make faster decisions. Faster decisions in high-stress environments are not always the right ones. And here is the detail that should stop every traveling gun owner cold. The moment you cross a state line, your duty to inform status changes. Your firearm does not. Reciprocity agreements cover your right to carry. They do not automatically transfer your home state's notification rules into the state you just entered. Know your category before you start your engine, not after you see the lights in your mirror. Now, I want to do something that most channels in this space refuse to do. I want to give the other side a fair hearing, because if I only ever tell you what confirms what you already believe, I am not educating you. I am just entertaining you. And entertainment does not keep you safe. So here is what the other side of this argument actually says and where they are not entirely wrong. Proponents of stricter duty to inform laws argue that mandatory disclosure genuinely improves officer safety, and the data offers some support for that position. When officers know in advance that a firearm is present, research suggests they can approach the interaction with greater situational awareness, which in certain circumstances may actually reduce the likelihood of a reactive, high-stress decision being made. Law enforcement organizations themselves have echoed this. Many officers have stated publicly that they prefer to know, not because they assume the worst about legally armed citizens, but because eliminating the element of surprise allows them to manage the encounter more deliberately and more safely for everyone involved. Here is where both sides actually agree, even if neither will admit it publicly. The content of the disclosure matters far less than the manner of it. How you say it, when you say it, the tone you use, the position of your hands when you say it. That is the ground where policy debates end and survival decisions begin, and that is entirely within your control. We have covered what to say. Now I want to give you what no one else is giving you, because here is the hard truth. Words are the last layer of protection, not the first. And if you are relying entirely on getting your phrasing right while everything else is working against you, you are one miscommunication away from a situation that no amount of correct language can reverse. So let me walk you through the layers that actually come before the words. In high-stress encounters, law enforcement officers process visual information faster than auditory information. What they see registers before what they hear, which means the position of your hands in the first 3 seconds of that interaction is already communicating something whether you intend it to or not. Both hands visible on the steering wheel before you say a single word. That is not a suggestion. That is a protocol. And before you reach for anything, your license, your registration, your carry permit, you ask permission out loud. Officer, to retrieve my license, I need to reach toward the glove box. Is that all right? You do not move until you receive a response. Every movement is announced. Every movement is permitted. Officers carry body cams. But that footage is controlled by their department. Your dash cam footage belongs to you. It is your record, your timestamp, your version of events captured in real time. Notify calmly and early. Officer, I want to let you know my vehicle has a dash cam that is currently recording. This is not confrontational. This creates accountability for both parties simultaneously. It is one sentence that can become the most important piece of evidence you ever produce. If you have passengers, especially children or anyone who does not know you are carrying you, need to control that dynamic before the officer begins processing multiple unpredictable variables. Officer, I have 2 passengers in the vehicle. I am going to ask them to remain still while we speak. Is that all right? You are managing the scene, calmly, cooperatively, but deliberately. I mentioned this earlier, and I want to return to it because it is genuinely one of the most misunderstood legal realities in this entire conversation. The Supreme Court ruled in Berghaus versus Tompkins that simply remaining silent does not invoke your Fifth Amendment right to remain silent. You must state it clearly, unambiguously, out loud, which means in the context of a traffic stop where you are carrying a firearm, the most legally protected version of saying nothing is still something you have to say. Know what that statement sounds like before you need it. Practice it, because the roadside at night, with lights in your mirror and an officer at your window, is not the moment to figure it out for the first time. Let me bring this home for you. 3 things I need you to carry with you after this video ends. First, The Supreme Court's 6-3 decisions are expanding your constitutional rights on paper, but not one of those decisions reaches into a traffic stop and protects you in real time. The gap between what the Constitution guarantees and what happens in 57 seconds on the side of a road, that gap is yours to close. Second, words are the floor. Your hands, your tone, your dash cam, your awareness of which category state you are in, those are the ceiling. Build toward the ceiling. Third, Philando Castile did everything right, and the system still failed him, which means your preparation cannot stop at following instructions. It has to go deeper than that. Now here is my question for you, and I genuinely want you to think about this. If the law is supposed to protect legally armed citizens, why does so much of the burden of survival still fall entirely on the citizen? Drop your state in the comments right now. Tell me whether you are must inform, inform if asked, or no duty. I read every single one. Subscribe and hit the notification bell. Because Wolford versus Lopez is coming. When that decision drops, and it could drop any day now, I will have the full breakdown within hours. Do not be the last person to know. I will see you there.